She refused to come over from the jail.
Oh, no, tell them that she needs to be here. When you are ordered to be in court, you're supposed to be in court. There will be none of this, oh, I refuse to come, because if you refuse to come, what's going to end up happening is the deputies are going to bring you anyway. And that you are a good candidate for probation, I'm not going to give you probation. I'm going to find you guilty. The enhancements are going to be true. The court is going to sentence you to the 10 years in the prison. You get credit for any time served. There's $1,000 fine. Didn't know it was stolen. You had meth in your bag. She's driving her with drugs. You can't tell me that you don't know the people you hang around with. All right. So it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial. If we were proceeding of the habitual, you know what your minimum is?
Ma'am.
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual. Discovery been received?
I believe so.
All right, you all need to do an acknowledgement of discovery before you leave. State, were you able to tender an offer?
Yes, Your Honor. I'm stepping in for Hunter today, Your Honor.
Okay.
And the offer is 10 TBC at this.
Oh, no. I just need to
Yes,
know
we
that.
did
an
get
offer.
an- Yes.
All right. So how old are you?
I am 53.
All right.
She's in jail. Today was supposed to be the plea deadline date.
Okay.
She refused to come over from the jail.
Oh, no. Tell them that she needs to be here. Okay.
I can't hear, ma'am.
All right. Are you able to hear now?
Yes, ma'am.
All right. So today is your plea deadline date.
Oh, okay. What do you want me to do?
Well, I mean, do you want a jury trial or have you reached an agreement with the state?
I haven't reached an agreement with the state.
All right, counsel, how long do you think this jury trial will last?
Could be a few days. I'm not positive.
Okay, sorry.
What I was Hunter is the prosecutor on this, and he'll be back next week. The prosecutor was here, says she does not have the room to negotiate. And Miss Essex was just indicted on the 8th of April this year, and I was appointed on the 19th.
Yes.
I'm just requesting, waiting for jury, plea deadline date for Monday so I can talk with her and Hunter. See if there's any chance to negotiate, an agreement.
All right. Ms. Ferguson, on this case, put it for Monday. There'll be no further extensions of plea deadline dates.
I appreciate that.
Thank you.
Garcia?
It says Matthew Allen. Oh, what's that with?
All right, Miss Essex.
Yes, ma'am.
All right, so let me just tell you something. When you
Okay,
are
sure.
when you are ordered to be in court, you're supposed to be in court. There will be none of this, oh, I refuse to come, because if you refuse to come, what's going to end up happening is the deputies are going to bring you anyway. And who do you think is going to end that argument when I tell the deputies to bring you? You're going to lose that argument. So this whole childish thing where people are not coming because you have something better to do, or you just refuse to come, you will be brought over. And you're going to lose that argument when you get into an argument with the deputy about whether you're coming to court or not. Do you understand?
I understand, Your Honor. I thought it was June 29th.
Here's the thing.
That's it.
This is why people are at the Bexar County Jail in custody, because you have someone in authority telling you
Oh,
that
okay.
you're scheduled to go to court today, and your thing is, no, I'm not coming. So I'm telling you, the next time a deputy tells you that you have court, you better come. Do you understand?
I understand, Your Honor.
All right, thank you.
Thank you.
Thank you, Judge.
Yes, Your Honor, I did. Thank you.
All right, you're charged with exploitation of the elderly. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor, I did.
Simple. They are proceeding on counts 4, paragraph A, and the enhancement. All other paragraphs were waived. According to the plea bargaining agreement, punishment is to be assessed at 10 years in the prison. There's $1,000 fine. The state opposes your application. Have both parties had a chance to review the PSI and TAP evaluation
Yes, Your Honor.
Yes, Judge.
And there was also a McMyoff
and the
evaluation.
McMyoff evaluation?
Yes,
All right, any objections?
no objections.
The state judge.
All right, state, do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
I have one witness, ma'am.
All right, you may call your witness.
Mr. Essex, how are you related to Kimberly?
She is my daughter.
Yes, your daughter. So you're familiar with her legal situations?
Correct.
Okay. You're aware of what she's charged with today,
Correct.
and you're aware that she is facing up to 10 years in prison.
Yeah.
Do you feel 10 years is going to help her?
As a father, 10 years, gee, but, I don't see at her age what benefit that would be. And as you explained to me earlier, maybe a different scenario would be was it the D, did you say the mental and alcohol treatment center?
Right.
Which sounds really more applicable to this case. I think Kimberly has obviously issues with alcohol and drugs, but also the mental issues have not really been addressed. She feels that she has drugs implanted in her stomach and her brain, just various things that I think she would benefit from the other program in the prison.
All right. Is there anything else you would like to tell the judge?
She's a good person. She just great heart.
I have no other questions.
Any questions?
Just a few, Judge.
All right. So, Miss Essex, I want you to know I listened to the testimony that was given by your father. But I've read the PSI report. Are you still, and I don't know if you want to call your client as a witness, she's given up the right to remain silent. But in the PSI, she's saying that she was given the credit card. But in looking through things, she wasn't given the credit card. And what she's spending the credit card on, I mean, there are many things with Dobby nails, going to the dermatologist, going to HEB, going to 7-Eleven, Best Buy, Shell Station, the Alamo Cafe, Best Western Hotel, SQZ, Trip Reggie, Specs Liquor, Crown Cap, and there are Dobby's Nail, 7/22/24, another Dobby's Nail, 7/22/24, all in the same day. Then there's Walmart, then there's Five Below, then there's Specs Liquor, then there's Ross, then there's Sushi Place, then there's FedEx, then there's American Best, Dollar Tree, Burlington, Wine and More, Chili's. So she, KFC, Torchy's, Don and Ben's Liquor. So is she still insisting? Oh, Saltgrass, is she still in?
Which ones?
And it says in the stipulations that her mom is at a retirement community
Yes.
and that people there became concerned. And that's when they discovered that the mom's credit cards were gone. And actually, the person who has guardianship of the mom became concerned as well.
Yes.
So it appears that your client was just spending money with no intention of paying it back because she didn't pay it back. Did she expect her mother, who's in a retirement home, to pay this back?
I can't answer that.
And it's like if she's saying that she had permission for it and it was a gift.
Not all of them. Not all of them.
Oh, you want to raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Can you tell you which ones?
No, you can lower your hand. State your name for the record.
Kimberly Mays.
All right, you can lower your hand. Your mom lives in a retirement community, so that I'm assuming that means that she's retired. Is that correct?
Yes.
And someone else has guardianship over her. Is that correct?
Yes, but I came back to her from the hospital. She had a heart attack.
No, my question is, does somebody else have guardianship over her?
I guess so.
And who would that be?
My brother,
I'm sorry?
my brother.
So when someone has guardianship over someone else, doesn't that mean that they're in charge of any type of spending of money? Correct?
Yes.
All right. So my understanding from reading the stipulations is you came to stay with her
Yes, yeah.
and you were staying with her, and then her credit cards were determined to be missing. And you didn't have permission from the guardian to take those credit cards, and you did. And were you going to Dobby's Nails, Specs Liquor Store,
Yes,
and were you going to Best Western,
yes,
HEB,
yes.
Torchy's,
That was with my mom.
all right, and
I did.
Walmart and Dollar General?
It's pretty extensive.
All right. So,
So,
oh, no, there's no need to apologize to the court. This is the state of Texas versus, so you can apologize to the state of Texas, maybe apologize to your mother, but my credit cards were not the credit cards that were taken. Do you have any questions of the witness state?
after I had all my stuff in the house, I didn't have a way to get in, any of my things.
You kind of understand what I'm saying, yeah?
Yeah.
You have a list of issues you've had with the law. So is it fair to say that this was out of character, or do you need help fixing your character?
I don't know what you want me to say. I really don't.
How many times have you been on probation?
I've been on parole.
Did they put you on probation in here or Travis County?
No, I did the county time and then I went to the prison for 29 days.
I'm gonna show you this, and it says that in August 2015, you're put on probation for 5 years.
Oh, okay.
That
That's a PSI, right?
Well, that was probation, and then just under 4 years later, you were revoked, sentenced to TC. Were you not on probation in
Okay,
Travis
I thought
County?
it's PSI. Is that different or no?
PSI is something that happens post
Or before it
finding
gets
of guilt,
sentenced, right?
re-sentencing,
Yeah.
yes. This looks like you're on supervision in Austin,
Okay,
the 3.5, almost 4 years. Is that fair?
yes, that is correct.
What happened?
I would have told you, it was a long time ago. I guess I was on pre-sentence trial, whatever it was, and then I ended up going to prison in 2014.
And you had indicated, Ms. Essex, that you were not under the influence of any substances when this happened. This offense that we're here for, is that true?
I wasn't under the influence of when I charged this stuff.
Yes.
No, I mean, I had gone to the liquor store and whatnot, but I wasn't intoxicated. What is that?
No, I'll pass the witness, Judge.
Any questions? Defense.
No questions, Your Honor. I do have a few things I'd like to address.
Yes.
While
Do
she
you have a
was,
trial court certification?
while she was in, Bear County, she wanted me to present those certificates to the court that showing that she is trying to be a better person. She's asking for, outpatient, intensive outpatient. She says she is willing to go to Laurel Ridge for an extended period of time. She has the threat of prison hanging over her head, which I think will motivate her strongly to help her keep out of prison and be successful on this probation. She had troubles last time, but she is older. she is motivated.
All right, so, Ms. Essex, I want you to know that I heard everything that has been said. I've internalized everything. And this is what I want you to internalize, right? You've got to realize that the person that you committed this offense against was your mom. Your mom is in a retirement facility. Your mom is in such a state that she has a guardian, which legally means she's not able to take care of herself. And what you did, under the guise of, I want to be with my mom, I want to help my mom,
Yeah.
you went into her retirement home, her apartment or community. And what you did was you took credit cards from a vulnerable person and you had no qualms about using those cards. And you would still be using those cards probably today, but not for the fact that the guardian of your mother said, hey, somebody's been using these credit cards. You had no intention for paying for that.
No, I would pay it back.
No, you say you would pay it back now, but that's because you have a criminal case. I don't think that you are a good candidate for probation. I'm not going to give you probation. I'm going to find you guilty. The enhancements are going to be true. The court is going to sentence you to the 10 years in the prison. You have credit for any time served. There's $1,000 fine. There's to be no contact with Dorothy Essex, Philip Essex. There's to be restitution, if any, to Dorothy Essex. I'll request a therapeutic community. There's to be no residing with any vulnerable person or anyone who's younger than 17 years of age or older than 65 years of age. The court, as previously stated, is giving you credit for any time served. Did you review the document entitled Trial Court Certification? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And yes, your agreement was that either I would grant you probation or either I would sentence you to 10 years in the prison. And I'm sentencing you to 10 years in the prison. Good luck to you. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Just a couple things, obviously, that the court follow the agreement. I don't believe Ms. Lumpkins has any history prior to this. She does have a minor dependent, Judge. I know that there's a fine, and I should have mentioned this earlier. She's not employed. She does care for the 3-year-old dependent. You could perhaps help her with her fine. And she took a parenting class already while in custody. Just wanted to make you aware of that.
All right. So you have a 3-year-old dependent?
Yes, ma'am,
And
but
if-
I signed over my temporary rights to my mother as well.
And it's, I'm assuming Child Protective Services is involved?
They were involved, but they closed the case as soon as I signed over the rest of my mother.
All right. So I'm telling you all, what's the child's name?
Roman Lumpkins, RHOMEN LUMPKINS. And his middle name is Connor, CONNER.
So it's Roman Connor Lumpkins? All right, so it appears to the court that the only reason why Child Protective Services is not in her life is because she signed over rights to her mom.
Yes.
So I'm not going to do this thing where you signed over your rights to your mom and then you go back and say, let me take my child back. Oh, well, I'm going to make sure that doesn't happen with conditions. So when's the last time you had employment?
Last time I had employment was about 6 months before I got incarcerated. I was donating plasma to help keeping my benefits and as well as giving my son clothes and shoes that he needs.
All right, what benefits?
EBT and Medicaid for him.
All right, so then you didn't have employment. What was your employment?
I let them know that I was just donating plasma and I would get $60 to $75.
Okay, that's technically that's not employment. So when's the last time
6 months before I got incarcerated.
doing
So
what?
I was working at Babes Old Fashions restaurant.
Okay. I always see that restaurant. I've never gone in and tried it because usually I'm passing by.
Kids eat free.
Yes, they do.
Oh, so you've been, okay.
Yes.
Well, let me bring out my pigtails. Going to school.
I only went to 10th grade.
All right, why?
I was never really involved with school. I was always just running around being a little hoodlum. Instead of doing education, I was just running amok.
So what are your plans? Because you have a child.
My plan is to get a GED and show him that his mom can turn around her mistakes and better herself.
All right, so you're gonna have to reside somewhere other than your mom's.
I don't have anywhere else.
Well, here's the thing, I'm not, at this point in time, I can't trust you with your child at this point in time. I mean, it's a no-go for the court. This is what the court is gonna do. There's $1,000 fine. That will be probated. Court will sentence you to 4 years deferred adjudication. There's to be 100 hours of community service restitution. Ms. Abrams, the parenting classes at the jail is not going to count towards her parenting classes. Once parenting classes are completed, 50 hours will be deemed satisfied. The other 50 hours will be deemed satisfied if she obtains her GED. If for some reason you're unable to obtain your GED, then you're going to have to do those 50 hours. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no unsupervised contact with minors. There's to be no residing in household with minors. There's to be no contact with Xiomara Perales. Course. Take into consideration 2025 PF 25148, 2025 AL 006849. The following will be done in custody. There should be a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, then follow TAP recommendations and field visits 1 time per month until further notice, or that can change if she's accepted in felony drug court because they will do their own field visits.
Sure.
I'm sorry, what?
How many months of field visits?
Until further notice. All right, Ms. Abrams, is there anything else? Thank you. There's to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. And what I can tell you, because you don't have custody of your child is not with you, so those benefits should stop for you.
Yes, ma'am.
Did you read the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. We can go off the record. Here's the thing. That 3-year-old can't even fend for themselves. That 3-year-old is 100% dependent upon you. And what did you do? You drove in a vehicle that was stolen with this Perales person. And then not only that, you all are doing drugs in the car. There's drugs in the car. And let me just tell you, meth stinks to high heaven. We had a case in this courtroom where someone brought in meth, and it took us forever to get that sent out of the courtroom. And you driving around with a 3-year-old impacting their brain cells with meth and marijuana in the car.
In my defense, she didn't let me know that the car was stolen.
Here's the thing, there's no defense. There's no defense to driving around in a vehicle. And let's say you didn't know it was stolen. You had meth in your bag. She's driving away with drugs. You can't tell me that you don't know the people you hang around with. How long had you known her?
On and off for 8 years.
All right, so you've known her for 8 years. So number one, you know what type of person she is. You've known her for 8 years. And if you were to tell me it was a complete stranger, then I'll be asking you, why are you getting in a vehicle with a complete stranger when you have a 3-year-old. If you want to put your life at risk, then go for it. But you're putting that child's life at risk by doing that. And signing over your rights to your mom, I already know that's the easy way out. And what ends up happening, people are in CPS court, and you know what they do? They sign their rights over to a relative. CPS gets out of their life, and then guess what they do? They go back to that relative, and then they have that child again. Not in this court. Good luck to you. Who's next?
I just want to talk to you about this.
Finds very remorseful for her actions. She regrets it. She's been incarcerated for at least 4 or 5 months now. She's had a lot of. She says almost a year. So.
All right. And
This was out of character for her. She regrets it. And so we'd ask the court to go forward with the plea agreement, because I think also probation can give her other help that she might need.
all right. So do you have any children? So you're not going to be able to live at this residence or have contact with Consuelo Franco. So where would she be staying?
Well, I was going to ask the court to, she probably won't be staying there, but she does want to have no harmful or injurious contact with her grandmother.
No, that's not going to happen.
With a mother?
Does the mother want her living with her?
I don't know that answer.
All right, because sometimes people just throw out names that they assume that people want them living with her and they don't. All right, this is what the court is going to do. Court is going to sentence you to 5 years in prison, suspended and probated for 6 years. There's an affirmative finding of family violence, the BIPP course. There's to be no contact with Consuelo Franco. I want a MIC evaluation. How long will that take, probation? There is going to be regular reporting by Zoom or in person. There's to be no contact with minors or the elderly. Now, probation, if she's working at McDonald's or somewhere, then that contact is okay. But outside of work, there's to be no contact with elderly or minors or vulnerable people. 150 hours of community service restitution. Probation, is there anything else she needs? We can do a TAP evaluation in custody. All right, good luck to you.
On or about the 9th day of February 2024, in Bexar County, Texas, the defendant Mariah Lopez committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violated condition number 2, on or about the 19th day of January 2024, in Bexar County, Texas, the defendant Mariah Lopez did then and there fail to submit to drug testing as directed by the court officer, supervision officer, or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Violated condition number 14G, on or about the 19th day of January 2024, in Bexar County, Texas, the defendant Mariah Lopez did then and there fail to register, attend a state accredited battering intervention and prevention program with approved agency in violation of condition number 14G.
How do you plead to that? True or not true?
Not true.
All right. And with regards to the other violations,
Oh, I'm sorry, Judge. We waive and abandon the other violations alleged in the motion.
any objection?
No objection, Your Honor.
All right, state, you can call your first witness.
Your Honor, I call Deputy Casares.
Your Honor, and if I may, before we proceed with testimony, for the purposes of the record, there was a plea offer in this case, and it was against counsel's wishes.
Oh, no. If you are going to put on the record what the plea bargain agreement was.
I wasn't going to put the plea on, Your Honor. I understand you're not allowed to be privy to the agreement.
Oh, okay.
Just that there was a plea offer made. I advised my client to take the offer. I thought it was a reasonable offer. There were some cases that were going to be disposed as part of that agreement. However, the client has rejected that offer.
Okay. All right. Do you wish to continue with this contested hearing? That's either yes or no. What's going to end up happening is the state has read the violations. You've said they're not true. So now the state is going to call witnesses. They're going to call this first witness. You can turn around. That's the witness at the back of the courtroom. They're going to come and testify. So do you still wish to plead with your pleas of not true? Or do you wish for the state to go forward with their case and call a witness?
I didn't know, I didn't know we were doing this, I'm sorry, I didn't.
Well, you were here yesterday and you knew we were doing an MTR and you didn't want to come from the jail. So it took us a while to get you to come from the jail. I had to sign an order for you to be brought over from the jail. So you were brought back today for a contested MTR hearing. What will happen in the hearing is the state is going to call their witnesses. If they present evidence and I find it true, then I will find it true. Then we'll go forward with whether or not I revoke your probation or not. So the question for you is, do you wish to continue with your plea of not true? Yes or no? Good afternoon.
Hi, good afternoon.
All right, could you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Rosemary Cáceres,
All right, state.
Sergeant, how long have you been with BCSO?
12 years.
And are you a licensed peace officer?
Yes, sir.
As part of your duties, do you recognize what I've marked as States Exhibit 1?
Yes, sir.
And how do you recognize it?
That's the video from our overhead camera. They're in South Tower booking.
Okay, and how do you, did you have an opportunity to view this?
I did review it, yes, sir.
Okay, and how do you know that you reviewed it?
I signed and dated.
Is this a fair and accurate copy of the recording that you accessed in regards to this case?
Yes, sir.
Okay. Your Honor, I offer States Exhibit 1. This is for the assault.
Okay, I have no objection, Your Honor.
All right, State's Exhibit number 1 is admitted without objection.
Do I have permission to publish this, Your Honor?
Yes.
And so aside from providing the video to the investigations part of BCSO, did you have other interaction with this case?
I interviewed both and I'm in charge of booking, so I'm aware of the inmates that are in our section.
Okay, and so do you recognize the defendant?
Yes, I do.
And how do you recognize her?
She was one of the inmates in booking that day.
Okay, and was she involved in an altercation?
Yes, she was.
And what happened?
She was in line to be transferred to the main jail. She walked away from the line and just went straight to Latrell and started striking her.
Okay, and do you remember the defendant's name? Would it help?
Latrell.
I'm sorry, would it help if you had to report to?
Oh, okay. Latrell Rebecca.
And that's the victim or the defendant?
Oh, the defendant.
I'm sorry, it's a little confusing. Is that the victim in this case?
I'm gonna object to her memory being refreshed while she's
Oh.
holding the document.
All
Your
right,
Honor.
could you read? And if there's no objection, I believe this is the question.
Judge, my objection is to her memory being refreshed and her reading from her.
All right, if that's a report, you can review it to refresh your memory.
Yeah, just
So state, what is the question?
Who was struck in that video?
Latrell Rebecca.
And who struck?
Oh, who was striking? Oh, Lopez, Mariah Lopez, I'm sorry.
And what was the date that this happened on?
February 10th, 2024.
Okay, and where did this happen?
South Tower booking.
Okay, and is that in Bear County, Texas?
Yes, sir.
I pass the witness, Your Honor.
Any questions?
Sergeant, you were present that day at the jail
Yes, sir.
and you have personal knowledge that Miss Lopez assaulted that the allegedly assaulted that other inmate?
Yes, sir.
And so you don't know that if the other inmate maybe had said something to Miss Lopez to get her, to kind of aggravate her?
She wasn't near her.
So you don't know what their interactions were beforehand, do you?
I do.
Okay, no further questions, Judge.
All right,
No further questions.
is this witness excused or subject for recall?
Excuse from the state, Your
Right.
Honor.
Excuse.
All right, thank you. All right, so with regards to the violation of condition number 1, state has already presented evidence on violation of condition number 1. Is there any evidence, and of course, defense, you don't have to present any evidence. Is there any evidence you would like to present on violation of condition number one?
None, Your Honor.
All right, with regards to violation condition number one, the court is going to find violation of condition number one true. State, are you still proceeding with violations of 2 and 14G?
No, Your Honor, we'll waive those.
Any objection?
No objection, Your Honor.
All right, then the court will hear requests from each party. What would you like to see done with regards to the motion to revoke?
Your Honor, we're asking for the 5 years. The defendant made a bargain to for deferred initially. She was unsuccessful on deferred. Her sentence was reformed for community supervision. She agreed to the 5 years. She didn't do great on community supervision. She picked up a new offense that brought her to the jail. And then once she was in the jail, she picked up another new offense. So Your Honor, at this time, we're asking for the 5 years.
All right, defense, what are you requesting?
Judge, we're gonna defer to the court.
You have no request?
I would allow Ms. Lopez to testify, you know, I believe she wants to make some announcements.
All right, you want to raise your right hand? Do you wish to say anything? If you do, you're going to be placed under the oath and you're going to be subject to this examination from the state.
Okay, Your Honor, it looks like at this time the client would not like to testify. Your Honor, we would respectfully request the court to sentence the client to 3 years in TDC.
All right, this is what the court is going to do. The court is going to grant the motion. Court will sentence you to 5 years in the prison. There's an affirmative finding of family violence, credit for any time served, and there's to be no contact with the complainant in this case. And then, all right, I'm showing you what's in the court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? All right, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on probation. Do you understand? All right, because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? Run concurrent, but whether or not it runs concurrent, that is completely up to parole. Let me ask you this. Have you already been revoked on your parole?
No, ma'am.
All right, then if you have not been revoked on your parole, then I can say that these state cases will run concurrent with your parole.
Are we off the record?
Yeah, we're not on the
Your
record.
Honor, I have these cases, I owe the state from 2014, 25-year sentence. And what I was asking as part of the plea bargain is I'm willing to give the state the conviction if they'll run it concurrent with.
Oh, no, here's the thing. This is what I'm telling you. I want you to listen to me carefully. I can put in the order that the case will run concurrent with parole. I don't have any jurisdiction over that. I can't force parole to make their case run concurrently with ours. For example, if you had a federal case, I can say, oh, this time is going to run concurrent with whatever they're doing on federal, but I have no jurisdiction to force them to do that. Parole is completely different from probation, but I can put on the judgment that it's a run concurrent with your parole, but I have no jurisdiction to force them to do that.
All I'm asking is if it runs concurrent with one of my case with my case number that I.
Okay, here's the
It is a county case. It is a Bexar County
here's the
case.
thing.
Yes, ma'am.
I know what you want. You know what you want? You want me to tell you
No.
that I can force these cases to run concurrently. That's what you want to hear from me. What I'm telling you is, and I want you to hear what I'm saying.
Yes, ma'am.
I can write on a sheet of paper and say, your cases are to run concurrent with your parole. Guess what? If parole does not want their case to run concurrent with this, it does not have to.
I think it's more of the case. I want to run concurrent with my case, with my active case and not my parole.
These two cases, if their agreement is there to run concurrently, they will be running concurrently.
So
If you have something that is on parole, I have no jurisdiction to force it to run concurrently. That's what I'm telling you.
as in, I didn't comprehend that part. I apologize. I didn't comprehend that part.
Yes, I can't force them to do it. I can put in our judgment that these cases are going to run concurrent with your parole, but I can't force parole to run anything concurrent with these cases.
So what happens to, I mean, I'm a little lost right now. What would happen with each case individually?
Individually, if you were gonna plead
One,
on,
one I saw 15 years and then I'm getting a 10 with it.
if you were to plead on both of these cases, I can order that these two cases will run concurrent and they will run concurrent. But if you want these two cases, if you're gonna plead to these two cases to run concurrent with your parole, I have no jurisdiction over what parole can do. I can put it in judgment and write down these two cases are to run concurrent with your parole. But you know what parole could do? Parole could say, yes, we're revoking him and his parole is not running
Well,
concurrent.
I'm going back to the Texas Department of Criminal Justice regardless, you know what I mean? I haven't been revoked because we're waiting on the outcome of these cases.
All right, so here's the thing. What I want you to do, we're gonna bring you back at 1:30 and I want you to internalize what I'm saying, not what you
No,
want.
you know, yes, ma'am, I understand. I'm just trying to comprehend and break it down how,
I can't break it down any further.
so,
I can't make the parole board run these cases concurrent with your parole. If I put in the motion or I put in the judgment, these cases are to run concurrent with parole, parole could still say, thank you so much, Judge Boyd, we're not running it concurrent.
even if they're Bear County cases?
Yes, even if they're Bear County cases. Parole is something completely separate. I have no jurisdiction over the parole authorities.
What if you can run it concurrent with the cases themselves and not parole?
I can say it's running concurrent, but again, parole can still say, we're not running it concurrently. So here's the thing, I know what you want. And we're gonna keep saying this same thing, and it's not, my answer is not gonna change. So come back at 1:30. All right, thank you. All right, everyone, we're taking our break. You're Soldania, you're here for a plea deadline date. So did you have a chance to internalize what I was telling you?
Yes, ma'am.
All right, so do you wish to have a jury trial?
Yes, ma'am.
All right, Ms. Ferguson, state, are you all going to be proceeding on the possession 1 to 4 or the injury to child?
The injury.
All right, so how long is this trial? How long will this trial take? All right, so Ms. Ferguson, if we could set this for a jury trial first thing.
Your Honor, good morning. Frankie Sandoval on behalf of Mr. Saldana.
Mhm.
Your Honor, I have some time this afternoon. Would it be possible for Mr. Saldana to and I to confer just a little bit longer?
Sure.
We'll get the jury trial date, but just to make sure that we are all on the same page as it were.
Okay, sure, most definitely.
I appreciate it, Judge. Thank you.
All right,
Your Honor, can I speak on the record?
what do you want to say?
I would like to object to the indictment and the evidence they used for the indictment. And I'm also reserving all my rights.
Mr. Saldana, why are we talking?
All right, so let me explain something to you, Mr. Saldana. I understand what you're saying. I'm internalizing what you're saying,
Yes, ma'am.
but this is what I'm going to say, and I want you to internalize what I'm saying.
Yes, ma'am.
If you need open heart surgery, are you following me with this scenario?
Yes, ma'am.
And the doctor tells you, hey, you need open heart surgery, and I'm going to do the open heart surgery. Do you go to the library, read a book, and tell the doctor, hey, I know you're doing open heart surgery on me, and this is the scalpel you should be using, and this is the stitch you should be using, and this is the way you should perform that surgery?
No, ma'am.
See, and people think that attorneys just talk, oh, I can do that. All they're doing is talking, but behind their talking comes a lot of knowledge and a lot of experience. And everybody thinks that they can do that. So for example, with regards to an objection to the indictment or objection to the evidence used for the indictment, that's something that your attorney will be taking care of if legally there's a reason for it to be. If he determines that legally there's no grounds for it, then he's not going to go forward with it. That's the way it works. So your attorney wants to have a chance to talk with you. I'll let you speak with him in the box. And what date, Ms. Ferguson? All right. Your jury trial is going to be July 2nd. If you want to do something with this case, you can do something with it today, or either what's going to happen is you're going to be set for jury trial on July 2nd.
Yes, ma'am.
And I'm sorry, Your Honor, just for advance information. I have a conflict on the third. I'm a prosecutor for a local municipality. And we
Okay.
have court on the third.
Oh,
I don't know if that would-
work around it.
Thank you, Judge.
You're welcome. All right, so just have a seat in the box, but your jury trial date is going to be July 2nd.
Yes, ma'am.
This is versus Valentin Saldana. Could I have parties announced for the record for the state
Marjorie Hilma for the state.
defense?
Your Honor, good afternoon. Frankie Sandoval on behalf of Mr. Saldana.
Are you Mr. Saldana? Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Saldana, did you review the document entitled True Bill of Indictment with your attorney, and did you understand it?
No.
All right, you need to speak up.
No.
All right, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are waiving the habitual, the enhancement paragraph, and we're proceeding on the underlying offense.
Any objection?
No objection, Your Honor.
All right, did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Ma'am,
Did you understand you're charged with injury to a child, bodily injury intentionally or knowingly? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
yes, ma'am.
All right, you're moving very slow with your answers. Do I need to speak up for you?
I think everybody can hear me pretty clearly. Yes, ma'am.
All right. I'm sorry, what?
Yes, ma'am.
Are you understanding everything?
Yes, ma'am.
All right. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Saldana, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you satisfied with the way you've been represented?
No, ma'am.
All right, do you want to go to a jury trial?
If I'm not satisfied with the way I'm being represented, no, ma'am, I don't want to go to trial.
All right. All right, so this is your attorney. This is what I know. We can go off the record. Here's the thing. An attorney will tell you, this is what the state is offering you. You can either accept it or reject it. This is a case that the state has made the decision to waive the habitual. If we were proceeding of the habitual, you know what your minimum is?
Ma'am,
What?
25.
And so you're saying you're not satisfied with your attorney when the state is not proceeding on the habitual.
I'm right. Yes, ma'am, I'm right.
What does that mean?
All right.
All right, we're back on the record. Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There are no applications. The state is taking in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
No.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the paragraph entitled waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court? Did you understand? Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Your Honor, the state offers state's exhibit number 1 and all attachments.
Any objection?
No objection, Your Honor.
Did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
In the interest of justice, that would be our request, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Saldana presents himself before you, accepting responsibility for the matter before you. As the court may be aware in reviewing his record.
Excuse me, just 1 second. Mr. Cox, if y'all can move down to the other end, we're on the record. That's okay. All right, we're back on the record. Yes.
Thank you, Your Honor. As the court is aware, Mr. Saldana is currently on parole on a previous case. He would respectfully request, and I make this request on his behalf, that although we understand and he understands not binding, we would ask that the sentence that will be imposed today by this honorable court run concurrently with whatever actions parole takes on his former case.
Court is going to do, as previously stated, the court is finding you guilty. The court will sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. This will run concurrent with 2014 CR 10282B. Take in consideration County Court Cause number 722472, 2024 CR 3082. There's an affirmative finding of family violence. There's to be no contact with Mallory, Malerie Saldana, Jaden Saldana, Jayden, and Irene Portelis. Is there anything else with regards to sentencing from either side?
Nothing from the state, Your Honor.
Not on behalf of Mr. Saldana, Your Honor, we appreciate the courtesy extended by the court and the state in allowing us to address this matter this afternoon.
All right. And then, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right. Those documents go to the defense attorney. All right, we can go off the record. Your minimum is 25 years in the prison. You understand? Your attorney was able to get you less than the 25 years. Do you understand? And I don't know what you don't understand. It appears that prison is not teaching you what it should be teaching you. But if you come back out and you commit another offense or alleged to have committed another offense, potentially based upon whatever offense that may be, you're looking at a minimum of 25 years. Do you understand? All right, good luck to you.
Mr. Reyna, we had requested some judgments from past hearings he's had and held, and we were provided those today. One of them, and I had received already one. I discussed that with my client,
and he kind of doesn't like the way I'm approaching everything and doesn't like the way or he feels that I'm not representing him accurately.
Mr. Rayner, come on down.
So we might want to talk to him because he's asked me to get off the case. And I told him that's something you have to discuss with the judge. And for the record, we have been relayed an offer to my client.
All right. So, Mr. Rayner. Are you Mr. Rayner?
Yes, miss.
All right. So it appears to the court that you do not want to come dressed for trial when you're supposed to be dressed for trial.
Well, believe it or not, Miss Boyd, I wasn't aware of this trial in the first place. And then
No, because
second-
here's the thing. Firstly, when a deputy at the jail tells you you're supposed to be dressed for trial, you're dressed for trial.
I wasn't
And when
told
your
to be
time,
dressed.
you were told before and you didn't do it. And guess what? If you ever come back to this court where a deputy at the jail has told you to dress for trial and you're not dressed, you know what's going to end up happening? You're going to be going to trial in that red jumpsuit. And you know why you're going to be going to trial in that red jumpsuit? Because it's going to have been your choice. I am not having you come back to this court again where you're pretending as though nobody told you you had a jury trial. The other thing, you're saying that your attorney is telling me that you want another attorney?
That's correct.
All right, then you need to hire one. Do you understand?
I don't have any support issues. Support at all as we speak right now at the moment.
What
And
support for what?
It's ordinary to hire an attorney.
Oh, well, then this is your attorney. This is what I've discovered, and I've told many people this before. This is what ends up happening. When you, as a defense attorney, are placed to represent somebody and you've been appointed to represent them, number one, there are certain qualifications that you must have. This is a third-degree felony. It may be bumped up to a second-degree felony based upon what's in the indictment. This attorney would not have been appointed to your case if he didn't have the qualifications to be on this case. I don't allow attorney shopping in this court. Whoever comes up on the wheel, that's who your attorney is. The state will tender an offer to your attorney because I require the state to tender an offer. State can make an offer and say, we're offering 20 years. The state can say they're offering the maximum. Guess what? Your attorney has absolutely really no control over what the state is offering.
So what's
Even if your attorney were to go to the state and say, well, these are the weaknesses in your case, and this is what my client is willing to accept, the state can still say, I am not going to offer your client what he wants. The only thing I will offer you is A, B, or C. And your attorney ethically is obligated to tender that offer to you. Now, you can accept it or not. That's completely up to you. There are certain rights you have when you're charged with the offense. One of them is whether or not you will accept an offer or not, and whether or not you will testify at trial, and what plea you will enter. Do you understand? So you're not getting another attorney. If you want to hire one, you are more than welcome to hire one. So this is your attorney. Next question.
Why does my case carry at least prison time and not probation?
Here's the
or
thing.
anything?
You will have to speak to your attorney. What I can tell you is there are certain cases, number one, that you're not eligible for probation. There are certain cases that if you go to a jury trial and if you are found guilty, you're not eligible for probation. There are some cases that if you go to jury trial, maybe you're eligible for probation from a court. But I cannot tell you whether or not, just based upon looking at your case, which would be the indictment for me, whether you're eligible or not. What I can tell you, though, usually if you have a repeater count and you go to a jury trial, you're not eligible for probation. So you need to speak to your attorney about that. And I'm sure your attorney will tell you whether or not you're eligible. Think of criminal history this way. if you have somebody that you loan money to, right? Let's say somebody comes to you and they say, can you loan me $50 and I'll pay you back next week? And you say, yes, I will loan you the $50. What are you going to use it for? Oh, I got to pay my electric bill, which that would be a great, good electric bill these days. And that person gets the $50 and they don't pay you back. And you just, you said you pay me back on this day. You're not paying me back. That person comes to you for a second time and said, look, I'm in dire straits. They're about to cut off my electric bill. I need $60. And you tell them, you know what? I gave you $50 just last week and you never paid it back. And they're like, I know, I'm so sorry for doing that, but I promise you this time I will pay it back and I really need the $60. So you loan them $60 and they don't pay it back. And then they come to you for a third time. You may say, I'm not going to loan you any money. I don't care what your problems is because I've loaned it to you 2 times before and you haven't paid it back. Sometimes people view criminal history that way. And when I was a prosecutor, sometimes people would view criminal history that way. They would say, you know what? I gave you probation before, you didn't do well on it, and you pick up another case. I gave you probation the second time, you didn't do well on it, and you pick up another case. So maybe that could be a reason why people make offers that they make. But what I want you to take away from this conversation is this attorney, according to the will, is qualified to handle the type of case that you're charged with. And I would tell you one of the qualifications they must have, and Mr. Gomez, correct me if I'm wrong, he has to have tried cases before, and he has to have tried felony cases before. You can't just have tried misdemeanor cases and then come to felony court and say, oh, I'm qualified. That's not how it works. So he's tried the necessary cases. And if you are upset by the offer that he is tendering to you, no, that is the offer that is the state has made. And in this court, I require everybody to treat each other with kindness. So I guarantee you, when the state made him that offer, the state wasn't mean. The state just says, this is the offer I'm making. And I expect you to treat your attorney with respect. I'm sure your attorney will treat you with respect. But again, if you want a different attorney, you need to retain an attorney. So that means you need to go out and hire an attorney. And if you don't have the money to hire an attorney, then this is your attorney. Do you understand? The other thing I want you, that's either yes or no.
Yes, miss.
The other thing I need you to understand, and again, we're not doing this anymore. If you are at the jail and they're ordering you dressed for court, that's me ordering you dressed for court because you're up for trial. And I will not have any qualms whatsoever with you going to trial dressed in that red uniform. And you and I both know that red uniform has several meanings attached to it, just the way the orange ones does and the blue ones does. The blue one for females, orange, just regular inmates. The red, gang member, age issue, in admin segregation. Yellow with stripes, pregnant, or just yellow, pregnant. Tan or grayish looking color, trustees. So if you want to come to trial dressed in red, that is completely up to you. Do you understand?
Yes, miss.
Do we understand each other?
Yes, miss.
Do you understand the offer that the state has made to you? That's either yes or no.
Yes.
Do you need to confer with your counsel anymore on the offer that the state has made to you? And if you would like to make a counter offer, I'm sure if you would tell your attorney, well, I want to accept this, but this is what I will accept. That's what's called a counter offer. But what that means is you're telling the state, I'm not accepting your offer. I will only accept this. So that means that you're rejecting the state's offer and it may or may not appear for you again. Do you understand?
Yes, miss.
And I'm sure this attorney will be able to tell you what your range of punishment is in this type of case. I cannot tell you that because I don't know the facts of your case. The only thing I have before me is an indictment. You understand?
Yes, miss.
Do you need to speak with your attorney some more? Do you need to see what evidence the state is saying they have?
No, miss.
Have you already seen that?
Not quite yet, but yes, I have.
Mr. Gomez, will you let him see that since we're all here?
If I could confer with him again.
All right, so your attorney is going to confer with you. And the state will let him see their file so you can see their file and see what they have, okay? All right, thank you.
Thank you.